Hello, and welcome to In the Privy Council, a podcast reviewing cases heard before the Judicial Committee of His Majesty's Most Honorable Privy Council, brought to you by the Legal Style blog. I'm your host, Elijah Granite. This week, we are discussing the Trinidadian case of Methanex Trinidad Titan, Unltd, and the Board of Inland Revenue, the citation for which is 2025 UKPC 20, Trinidad and Tobago. As a reminder, because Trinidad and Tobago is a republic, this case is decided directly by the board rather than by His Majesty. For the purposes of this podcast, the two relevant issues in this case are the twin questions of when a transaction is either, for the purposes of taxation, fictitious or artificial, two terms that appear in many country statutes concerning taxation. Specifically, the Trinidad branch of the multinational group of companies Methanex, the name incidentally comes from its production of methanol, paid US $85.4 million in dividends to its Barbadian holding company, Methanex Barbados, which owns 100% of Methanex Trinidad. Under a Caribbean Community or CARICOM treaty, dividends between Trinidad and Barbados are exempt from double taxation, meaning that the withholding tax in Trinidad would not apply. However, the revenue in Trinidad argued that these dividends were ultimately being paid via Methanex Cayman along the way to the ultimate holding company, Methanex Canada. And thus, Canada, not being a Caribbean country, is subject on those payments to Trinidadian withholding tax. The transactions that alerted the Trinidadian revenue were as follows. Methanex Trinidad, having paid some money, sent a dividend in 2007 and yes, this case is another one where the tax courts seem very unacceptably slow. Anyway, in 2007 to its holding company, as we've said, Methanex Barbados. It did so by wiring the money from Methanex Trinidad's bank in New York to Methanex Barbados's account at the Royal Bank of Canada in Vancouver, in Canada, where Methanex Canada, a Canadian company, was headquartered, and ultimately where, by treasury agreements between the subsidiaries, Methanex Canada was a signatory with control to the account of Methanex Barbados. And Methanex Barbados then wired dividends from this Royal Bank of Canada account to its holding company, Methanex Cayman. This was all done to Methanex Cayman's account in Vancouver, again in Canada, which ultimately paid a dividend to the, again, Canadian company, Methanex Canada. Now, the Trinidadian revenue pointed out that this dividend never touched Barbadian soil. The entire transaction was a fictitious way of avoiding dividends. In the Court of Appeal, hearing the appeal from the tax board, my lord, Justice of Appeal Mr. Justice Rajkumar, found that this entire set of transactions was not an acceptable arrangement, but rather an attempt of disguised or fictitious transaction by which the entire Trinidad to Barbados to Cayman to Canada structure was solely a conduit to pay profits to Canada, where, there being no treaty, withholding tax would apply. That brings us to the board to which Methanex Trinidad appealed. For the board, my lord, Lord Richards of Camberwell, started by noting that the provision in Trinidadian legislation, that is Section 61, subsection 1 of the Income Tax Act, allowed the tax board to disregard any transaction that was, quote, artificial or fictitious. Now, those two words, artificial or fictitious, had previously been considered by the board in the context of equivalent Jamaican provisions. And the board, in considering those words, artificial or fictitious, took care to distinguish them. In Ceramco Limited Superannuation Fund Trustees and Income Tax Commissioners, 1977, Appeal Cases, page 287, Jamaica, my lord, Lord Diplock, at page 298, held that a fictitious transaction was one to which those who are ostensibly the parties to it never intended it should be carried out. By contrast, his lord gave artificial a wider meaning than the essentially fraudulent meaning his lordship ascribed to fictitious. This wider meaning was expanded on by my lord, Lord Walker of Gestingthorpe, in another Jamaican case, Commissioner of Taxpayer Audit and Assessment and Cigarette Company of Jamaica Limited, 2012, One Weekly Law Reports, page 1794, Privy Council, Jamaica. There, Lord Walker of Gestingthorpe said that a transaction is artificial if it has, as compared with normal transactions of an ostensibly similar type, features that are abnormal and appear to be part of a plan. They're the sort of features to which a well-informed bystander might say, this simply would not happen in the real world. So looking at these two criteria, Lord Richards of Camberwell started with the question of fictitiousness. The Court of Appeal said the transaction was fictitious because they were not simply dividend payments from Methanex Trinidad to Methanex Barbados, but rather elements of a multi-stage transaction. The end point was ultimately to pay Methanex Canada. Yet, his lordship noted that the fact that a payment was given from A to B and subsequently from B to C did not render the parties to the A to B payment or the purpose thereof fictitious. Indeed, in a group of companies, we might expect, indeed require, that B would then have an obligation to pay profits to C, much as A, being a wholly owned subsidiary, had an obligation to pay profits to B. Nor, per the Lord Richards of Camberwell, was this transaction rendered fictitious by the fact that the money went physically, on wires, straight to Canada, where the Canadian company controlled access to the accounts. The issue here is not if, for convenience, Methanex Barbados lets Methanex Canada's employees be authorized signatories. Rather, the question is the ownership, the beneficial ownership of the bank account. There's no evidence that Methanex Canada had any ownership over the funds in the Methanex Barbados account, or was entitled by these agreements, allowing it to be a signatory to treat the Methanex Barbados money as its own property. And the ownership is what matters for fictitiousness. And recall again, fictitiousness is about, are the parties to the transaction or the nature of transaction wrong? And here, the parties are who they say they are, and the transaction is indeed a dividend. That brings us to artificiality. For the Court of Appeal, the whole transaction reeked of artificiality, because the quick payment of dividends up the chain at the apparent request for dividend money of the ultimately controlling Canadian company smacked of a plan, rather than independently. Methanex Trinidad decided to pay Methanex Barbados. Methanex Barbados, after some contemplation, decided to pay Methanex Cayman, who, after some further thought, independently decided to pay Methanex Canada. The board could not accept this analysis because that test for artificiality, requiring each stage to be independent, completely ignores that the test laid out by my lord the Lord Diplock and Lord Walker of Gestingthorpe is one of legitimate commercial purpose. As a wholly owned subsidiary of Methanex Barbados, Methanex Trinidad has no legal way to pay dividends to Canada, except by legally declaring them to its sole owner, the Barbadian company. And yet, as part of a group of companies, has a legitimate commercial purpose for paying these dividends up the chain. As his lordship said, it cannot be artificial to execute a legitimate commercial decision by the only available legal means. The existence of Methanex Barbados was not a sham, nor artificial, and therefore paying money to the only shareholder and therefore the only legal recipient of dividends could not be artificial by Methanex Trinidad. It, in fact, was required. Let's recall Lord Walker of Gestingthorpe's test, that the artificial transaction is one no bystander would recognize as real-world business. And here we can see some comparison to the idea of the officious bystander that pops up in other areas of the law. In applying this test, the board recognized that paying dividends up the chain of a group of companies is not only a legal necessity, as we've discussed, but a common business practice, identifiable in the commercial world with a commercial need. In the context of a group of subsidiaries, and context is absolutely crucial in evaluating artificiality, which depends completely on the commercial nature and legitimacy of the transaction in its context. These were transactions grounded in real-world sensibility. Our hypothetical reasonable bystander would see these transactions and go, yes, perfectly normal, exactly as things are done in the real world. With this resolved, along with another issue we won't discuss on the podcast relating to Methanex Barbados' tax residency, the board allowed the appeal, and Methanex Trinidad won't have to pay tax, withholding tax that is, on its 18-year-old dividends. Moving to our analysis of the case, and beyond my usual gripe of how long these tax cases take, 18 years is absurd. The takeaway here is the courts will read statutes designed to stop abuse of the tax system in a way that does not prevent legitimate actions for recognizable commercial purposes, regardless of whether that is a side effect of letting companies minimize tax obligations. Leaving aside that, as is well known, every taxpayer is entitled to structure his affairs within the law and rules so as not to have to pay more tax than is required. It is also the purpose of the tax system to facilitate business, to allow it to go on, and simply ensure that the revenue is paid the fair share so that the public purse can go about doing its important things. In that context, let's remember that a multinational company paying up a chain of dividends is a recognizable commercial and legal necessity to operate. After all, when operating in multiple countries, it's usually best and sometimes even a requirement to incorporate in the country in which one operates, and then each subsidiary pay dividends to its parent abroad because the parent is the shareholder. If the Trinidadian revenue had their way here, they might threaten the ability of international companies to operate in smaller jurisdictions like Trinidad, and even worse, to affect the ability of certain legal persons to take advantage of rights incorporated into Trinidadian domestic law as part of a treaty on Caribbean economic integration, the purpose of which is to allow companies in these small jurisdictions to work together and to avoid bureaucratic barriers to economic cooperation in a region that needs it. If the Trinidadian revenue had had their way, it would have frustrated the effect of the CARICOM Treaty and have hurt the Trinidadian economy, and worse yet, deprived the revenue of all the tax paid by the subsidiary and its employees. This goes beyond just commercial sense, too. When the drafter of legislation includes a broad word like artificial, the courts have to take care to construct it both to do the primary thing, which is to give effect to the will of Parliament, while also adding in clarity so that the person obeying the law can have some idea by what is meant. Lord Diplock rejected the idea that artificial was so narrow as to be pleonasm, as to mean the same as fictitious, its neighbor, but was careful, along with the later judgment of Lord Walker of Gestingthorpe, to clarify that artificial was not in the eye of the beholder being the tax authorities, who naturally have their own vested interests here, but rather a careful, objective, evaluative exercise considering the commercial and factual reality of doing business. This approach to statutory interpretation is a wise one. It should be commended whenever Parliament inserts a word like artificial with only an ordinary English meaning as a guide. Well, thank you very much for listening to another episode of In the Privy Council, brought to you by the Legal Style blog. I've been your host, Elijah Granite. If you want more legal content, subscribe to the podcast on your platform of choice, visit our website, legalstyle.co.uk, or follow us on Twitter @LegalStyleBlog. If you have any comments, suggestions, rants, or raves, the email of the podcast is editor@legalstyle.co.uk. We also welcome any ratings or reviews on your usual podcast platforms. Until next time, goodbye, and remember, God save the King.